I'm a solicitor and I'm the head of private client and family at Douglas Wemyss Solicitors. Today I'm going to talk about the effect on wills of marriage and divorce. Many people do not realise that a will is normally automatically revoked by marriage. This is the result of an old law which originally goes back to 1837, when married women had very few rights, and was designed to ensure that a new wife was not left without being provided for if her husband died. The will is completely revoked, resulting in an intestacy if a new will is not made. Under current intestacy rules, the first £250,000 of a deceased estate goes to a surviving spouse. What happens to the rest depends upon which other relatives survive. There is an exception to the automatic revocation in that it is possible to write into the will that it will not be revoked on marriage to a particular named person. This can only be done by reference to a specific person. It is not possible to insert a general provision that a will should not be revoked by marriage. It is important to ensure that these clauses are correctly worded. Failure to realise that marriage revokes a will can lead to unfortunate and unintended results. To give a couple of real-life examples, Mrs. A, who was divorced, made a will in favour of her daughter of her first marriage. After making the will, not only did she remarry, but she separated from her second husband and started divorce proceedings. She died suddenly before the divorce was finalised, and so her estranged husband was entitled on her intestacy. In this particular case, the size of the estate was such that the whole of it went to the husband, and the daughter had no entitlement. Mr. and Mrs. X married late in life. They had both made wills several years before they married one another. The main beneficiary under Mrs. X's will was her son, while Mr. X's was in favour of friends. Both wills were revoked by marriage, so both died intestate. Mrs. X died first, and Mr. X became entitled to her whole estate on her intestacy. Mr. X then died, leaving surviving relatives with whom he had had no contact for years, who were then entitled on his intestacy to all of the couple's assets. These stories stress the importance of making a new will following marriage. In addition, anyone who is in a settled relationship should consider whether they can prevent their will becoming unintentionally revoked if they marry their partner. Divorce, on the other hand, does not completely revoke a will, but only causes a gift to the former spouse to lapse. Whilst this is often what is wanted, it may not be desired in every case. Furthermore, the will may not include adequate alternative provision in the event of the failure of the gift to the former spouse. An appointment of the former spouse as executor is also automatically cancelled. This could leave the will without executors if the former spouse was the sole executor, or with too few executors if the former spouse was one of two executors and the situation is one where more than one executor is needed. This results in extra complications for the family following death. Your will should always be reviewed following a life-changing event such as marriage or divorce. For advice on wills, you should see a solicitor. Thank you very much for listening.